Greetings, my fellow freedom lovers and sovereign thinkers. This is LL3's newest podcast. My name is Craig, and transmitting from the beautiful swampy mangroves of South Florida. Today's date, October 20th, 2014, on a Monday to be exact. Yep, all the hoopla about the elections, who's gonna win, who's gonna lose, we need red, we need blue. Well, all I have to say, whether it's red or blue, expect to get screwed. That's all I have to say about the elections. Yeah, it has some pros and cons, don't get me wrong. But I just gotta get a crack of humor of this whole election campaign hype. However, I'm going to be discussing today the 10th Amendment to the U.S. Constitution, plus a couple of other reports related to that. And this is another article done by David J. Shestowska. Hopefully I pronounced his name right, But yeah, so I will put those footnotes on my Spreaker page. All right. So let us begin. This one actually was written by him on September 10th, 2014. And the quote: "The 10th Amendment is the foundation of the Constitution." Thomas Jefferson made that statement. And as it reads, the 10th Amendment: "The powers not delegated to the United States by the Constitution, nor prohibited to the states, are reserved to the states respectively, or to the people." That's part of our Bill of Rights culture, to be exact, in the United States of America. So anyone else don't know? Now you do. All right, let's proceed. Among the questions raised by opponents of the Constitution during the ratification debates was the lack of an express limit on federal power, and that it would be a danger to individual freedoms and to the power of the states. In response to this concern, the Constitution proponents argued that the central government could exercise only the powers named in Article 1. This was an argument developed from agency law, something the drafters at the Constitutional Convention were very familiar with. In various debates, writings, and publications, the Federalists assured the states would retain power over the most domestic issues, including but not limited to governance of religion, training the militia, and appointing militia officers. Think about that now. Part of their duties: control over local government, most crimes and state justice systems, family affairs, real property titles and conveyances, wills and inheritance, the promotion of useful arts in ways others than granting patents and copyrights, control of personal property outside of commerce, the laws and torts and contracts, except in suits between citizens of different states, education, services for the poor and unfortunate, licensing of taverns, roads other than post roads, ferries and bridges, regulation of fishery, farms, and other business enterprises. Neither the arguments nor the listings were satisfactory to the anti-federalists, as argued by Patrick Henry. "If we trust our dearest rights to implication, we shall be in a very unhappy situation." Makes sense. Look what's happening today with the federal government, trying to centralize everything little by little. Well, I will continue. The Federalists promised to address these concerns with amendments if the Constitution were ratified. The 10th Amendment. Not wishing to rely upon the implications of agency principles alone, many state conventions included recommendations for a Bill of Rights along with their ratification resolutions. The new government went in effect in 1789, and the concerns of the anti-federalists remained alive. Shortly after the first Congress convened, New York and Virginia filed applications for and Article 5 Convention on Amendments. The Federalists were in control of Congress and led by James Madison to keep their promises and to avoid an Article 5 Convention proposed 12 amendments. The 10th Amendment reads, now to repeat it again, the power is not delegated to the United States by the Constitution, nor prohibited to the states, are reserved to the states respectfully or to the people. The 10th Amendment have been the 12th offered, but the first two weren't ratified. The 10th Amendment in reality confided the agency principles that have been relied upon by the Federalists in their arguments for ratification. The 10th Amendment has become a rule of construction, directing the courts how to interpret the Constitution. It essentially tells the courts to follow the law of agency, that a principle, in this case the people and their alternate agent, the states, retain authority over all subject matter not outlined in the agency agreement, the Constitution. The purpose of the 10th Amendment. This amendment was to answer concerns that the Constitution's central government would not usurp powers intended to remain with the states and the people. The key principle of the Constitution was originally quite simple: positive grant of enumerated powers. The people appoint the federal government their agent for certain purposes and their own states for other purposes. The 10th Amendment explains that the federal government is authorized to exercise only those powers which are specifically given to it. It makes clear the principles of federalism underlying the Constitution. The 10th Amendment and McCulloch versus Maryland. In 1819, Supreme Court Chief Justice John Marshall in McCulloch versus Maryland, which is a link for that, turned aside the concept that the 10th Amendment limited the central government to specific constitutionally granted powers. Marshall ruled the Constitution granted not only the enumerated powers, but an extensive collection of implied powers. Marshall emphasized a word missing from the 10th Amendment. The Articles of Confederation had limited the central government as follows. Each state retains its sovereignty, freedom, and independence, and every power, jurisdiction, and right, which is not by this confederation expressly delegated. Emphasis added. Marshall ruled that since the 10th Amendment differed from the Articles of Confederation provision by omitting the term expressly, the amendment's intent was to give Congress an array of implied as well as explicitly delegated powers. Since the central government's power was not expressly limited, its power could expand well beyond the specific constitutional grants of authority. The necessary and proper clause to allow government authority to be exercised in areas well beyond limited constitutional grants. Marshall relied upon the necessary and proper clause. The Congress shall have power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by the Constitution in the government of the United States or in any department or officer thereof. In determining the 10th Amendment contained no express limitation provision, and that the Congress had the authority to make necessary and proper laws to execute the enumerated powers, Marshall's ruling was contrary to the Federalist ratification arguments. The 10th Amendment in the 21st century. Marshall set the stage for 10th Amendment atrophy. This is what happened over the centuries. The listing of subjects reserved to the states promised by the Federalists has been subject to intrusive and in some instance exclusive federal control. The fears of the anti-Federalists have come to fruition. The Supreme Court has given the 10th Amendment some life in recent years with rulings limiting the federal government from commandeering state government to execute federal policy, but those victories for local government are few. The states cannot rely upon federal courts to truly act as a limit on federal power. The states can only protect their constitutional prerogative through their own actions. There are state exertions of 10th Amendment powers of late, with state actions on subjects on both marijuana and the Second Amendment to right to bear arms. In some states, 10th Amendment arguments are put forward in opposition to Common Core. The 10th Amendment vitality depends not on court decisions, but strong state leaders acting in the local interest of their citizens. The Federalist. Articles 2, Section 8 defines the subject upon which Congress can pass laws. The Federalists argue the legal maximum of designatio unis. The designation of one is the exclusion of the other. The idea being that by naming specific powers, any unnamed authority was withheld from the federal government. Specific powers of the President and the Supreme Court are found in Articles 2 and 3 respectively, with the same argument applied. The Constitution provides two methods to propose amendments. See Article 5 for full explanation. There are multiple contemporary efforts to call an Article 5 convention. I think I made a mistake here. 1, 2, 3, 4. Here's number 4. The Second Amendment proposed was ratified 202 years later, becoming the 27th Amendment. Yep, I do remember that. They can stick it, as far as I'm concerned. 5. A rule of construction is a legal concept developing over time that tells a court how to read a document or a law. The principles behind these rules are generally to arrive at the intent of the people who created the document or passed the law. 6. This was the operating agreement between the states from 1776 to 1789 when the Constitution went into effect. 7. As a practical matter, federal courts are 1/3 of the federal government. When the 17th Amendment provided direct election of the Senate rather than the appointment by state legislators, the voice of the states in the Congress was silent. So, in other words, it was centralized. Oh, absolutely. You have to look at everything thoroughly. And I did read looking at the 27th Amendment and heard it on, I think, what show was it? What show was it? Armed American Radio, to be exact. And it is so hilarious about the whole 27th Amendment because they try to, if I'm correct, try to do lots of other things, pay raises and all that good stuff. But the 10th Amendment is what it is, my friends. It's the rights of the people, reserved by the people and the states. So technically, federal law does not supersede state law unless it's constitutional. So, good example, the Patriot Act, the USA Patriot Act. The states and local municipalities are entitled to nullify it. It's legit. If I'm correct, right now, 400 municipalities and 8 states said no to the USA Patriot Act. And in addition, other states and local municipalities are doing the same thing with the NDAA on detaining people without due process, judicial due process to be exact. So that's why the 10th Amendment is essential. Many folks believe the 10th Amendment is dead. Actually, I say it was dormant. However, it can always be revitalized and exercised honorably. That's why this is part of the Bill of Rights culture. If you screw with one, you screw with them all. And what does the Bill of Rights stand for? Government keep out. That's all I have to say on that area. And we just do go through another one here by the 10th Amendment Center. Blueprint for success, turning federal acts into hot air. It's all like 10th Amendment related. So, and let's just proceed here. This is done, 10th Amendment Center, and it says here, a little quote, without local enforcement by compliant local authorities, the will of central government is not much more than hot air. That's by Hans Hermann Hoppe. And as it reads, in what should be seen as a blueprint for effective resistance to federal power, the Nashville police refused to help Secret Service after a frantic call for backup to enter search a resident's home without a search warrant. That's according to the Nashville station News Channel 5. And there's a link for that. So I'm going to put all these up on my Spreaker page, and you can look at it yourself. And I've seen it, so it is really great. So I will continue. A Secret Service agent made a frantic call for backup to the Nashville police after he and another agent went to the home of a Nashville man investigating threatening comments on Facebook about the president. The man posted them had refused to let the agents into his house. He shoved the door in our face and went around the corner. Looks like we're not sure if he had a gun in his hand, the agent told a 911 operator. The resident refused to come outside and shouted back, "Show me your warrant," said Police Chief Steve Anderson. While much of the media attention focused on the fact that the SS agents asked a police sergeant to wave a piece of paper in an apparent effort to dupe the resident into thinking that they indeed had a warrant when they did not, most coverage missed what might be even more important. Refusal to participate with federal acts on a local level is legal, constitutional, and effective. Father of the Constitution. In fact, this is exactly what James Madison, the father of the Constitution, recommended as the way to stop federal overreach, whether those federal acts are constitutional or merely unpopular. In Federalist Papers 46, Madison advised a refusal to cooperate with officers of the Union as the way to stop such federal acts. He also said that should this and 3 other steps be taken in multiple states simultaneously, it would present obstructions which the federal government would hardly be willing to encounter. In other words, those federal acts would be nearly impossible to enforce, as Judge Andrew Napolitano put it earlier this year. They need help. While the federal politicians and bureaucrats would like to believe that the federal government is all-powerful and will to do what it wants, when it wants, this couldn't be further from the truth. The Secret Service wasn't able to carry out its warrantless raid without help from the local police. In fact, they were so desperate for help, they were frantic. A vast majority of raids carried out by the Bureau of Alcohol, Tobacco, Firearms, and Explosives only occur with significant assistance from state or local resources. The Drug Enforcement Agency, DEA, barely has the resources to shut down just a fraction of marijuana businesses in just one city out of 20 plus states nullifying the unconstitutional federal prohibition on that plan. When the NSA builds a new facility to house all your private communications, it relies on things like water or electricity provided by state or local agencies, or it won't have the resources to stay operations. The Affordable Care Act is already being crippled by states that have refused to implement parts of the federal program, and further state resistance is likely to bring the entire act down. The National Park Service can't shut down a park without help from the states. And there's a link for that too. It happened in Wisconsin. The FBI's facial recognition program won't go anywhere without images supplied by state departments of motor vehicles. And most unconstitutional foreign policies rely heavily on state National Guard troops carrying much of the load. During the partial federal shutdown of 2013, the National Association of Governors admitted States are partners with the federal government in implementing most federal programs. Perhaps rarely work when only half the partners are involved. And some hot air quotes. I don't ask that you place hands upon a tyrant to topple him over, but simply that you support him no longer. Elente de la Bote. Hopefully I pronounced that right. I don't know about, I will continue. Like the proverbial house of cards, the federal government cannot continue on its path without help. It needs help from state governments, from local governments, and from you. Every state, every locality, and every individual refuse to cooperate with officers of the Union in every possible situation, as James Madison advised. With time, dedication, and persistence, people can turn federal gun control, NSA surveillance, hemp farming bans, national health care, and so much more what they should be. Hot air. Oh, yeah. And like I said, there's some good links on here, too, and Common Core is a fantastic example. Because the truth of the matter is, if you look it up, National Association of Governors supposedly endorse it. So what does that mean? Centralization. So I do really admire these article here on the 10th Amendment. So like I said, it's people gotta start exercising it. Well, of course, someone from Washington says they know better. You just gotta give them a taste of flatulence or fart, and I say that sarcastically. Alright, so the next one here came from Shall Not Be Infringed, even though it's came out like a while back as well. And it's entitled Breitbart Reports on Gun Control Nullification by Sheriff in Maryland. In a recent article at Breitbart News, AWR Hawkins report that gun control advocates have their sights aimed at Wicomico County Sheriff Mike Lewis in Maryland for having the audacity to claim that he isn't bound to enforce federal laws that restrict the right to keep and bear arms and violate the Second Amendment. In fact, Lewis went even further, saying he would actively resist any federal attempts to enforce such laws. As long as I'm sheriff in this country, I will not allow the federal government to come in here and strip my citizens of their right to keep and bear arms, he said. I can tell you this, if they attempt to do that, it will be an all-out civil war, no question about it. The Coalition to Stop Gun Violence has started an online petition to bar Lewis from teaching law enforcement skills and tactics to up-and-coming law enforcement personnel. GSGV Communications Director Ladd Everett said, when you employ violence against your government essentially to affect policy decisions, you are damaging the principle of political equality. I'm sorry about that. It looks like Director Ladd Everett may speak with that particular rhetoric with the bowl of Palmolive soap in his hand and address it. Okay, well, you'll be damaging the principle of political equality. You know what? Shut up. And I will continue. No, Everett, what Lewis is doing is stunting federal encroachment on our liberties by nullifying their unconstitutional laws in his county. Lewis also demonstrated he is capable of comprehending the plain meaning of the Second Amendment, which says our right to keep and bear arms shall not be infringed. I always recommend to my friends, I know I say this repeatedly, add the 9th Amendment to the U.S. Constitution as well. And proceed. As radical as Lewis's warnings of a civil war may be in the event of gun confiscation, it is only because he understands, as the founding fathers did, that before tyranny can ever complete its grip around the people, they must first be disarmed. Study gun control and confiscation, my friends. Or read stuff like Death by Government, or go to the jpfo.org. They have plenty of information on that, because the past is today's greatest teacher. And as I read along here, in Federalist 46, James Madison argued that even if the federal government grew too powerful and formed a regular army to carry out its orders, the sheer number of armed citizenry and militia will make it impossible for them to succeed. An armed populace, he argued, served as an indispensable check against a central government. Here's a man who's a Christian by faith, okay? So, just to let you guys, comprehend that. In conclusion, he wrote, those who are best acquainted with the last successful resistance of this country against the British arms will be most inclined to deny the possibility of it, besides the advantage of being armed, which the Americans possess over the people of almost every other nation, the existence of subordinate governments to which the people are attached and by which the militia officers are appointed forms a barrier against the enterprises of ambition more insurmountable than any which a simple government of any form can admit of. This is why it is crucial for us to protect our right to keep and bear arms by getting states to pass their own Second Amendment Protection Act. So there's a petition drive for that. Check it out, and I recommend it. Alright, well, like I said, this is really great stuff here. I'll give you an example about the 10th Amendment and why it is part of our Bill of Rights culture within the United States of America. It doesn't matter what party you're in, Democrat, Republican, Socialist. Doesn't matter at all. Race, color, creed, sexual orientation, etc. As freedom-loving, sovereign-thinking individuals, all my fellow brothers and sisters in the United States and the rest of the world should know about our Bill of Rights culture. And we all have to preserve it with dignity, love, and express it in good faith. Alright. And that's all for now. I thank everyone for listening. You can hit me with your comments, criticisms, love letters, hate letters. You curse me out, but you know, I'll still be inspired. You can hit me on Facebook, Twitter, Google+, iHeartRadio, and just type in Look the Third, some with the number 3 or Roman numeral 3. I got other like social media groups in there, Free Speak, World Truth, and what's the other one? RTR. Okay, which is stands for Restore the Public. And like I said, thank you for listening. Plus, always remember that demoniac resistance is healthy for the soul and can liberate societies. Until then, take care of yourselves, keep on spreading the love, and may your guardian spirits be with you.